how to keep your inheritance safe from divorce in California. If divorce happens, could you lose part of your inheritance? Not if you plan ahead. I'll explain how to protect your inheritance under California law before or even during marriage to safeguard what's rightfully yours. Hi, I'm Dr. Ray Gervasio. In 30 years as an attorney, I've seen families torn apart, wealth drained, and years wasted in court, all because of poor planning. We make sure that doesn't happen. If you want to protect what you've built and keep your family out of court, call us at 408-945-3950 for your initial consultation. How California law treats inheritances in divorce. California is a community property state, meaning most assets acquired during marriage are split 50-50 in divorce. But inheritances are treated differently. They're considered separate property even if received during the marriage. However, that protection can easily be lost. If you mix your inheritance with joint assets by depositing it into a shared account, buying a home together, or using it alongside marital funds, it may no longer qualify as separate property. In legal terms, this is called transmutation. Even if the inheritance was originally yours alone, proving that in court can be difficult without clear documentation. The burden of proof falls on you. That's why proactive estate planning matters. The right trust strategy helps protect your inheritance clearly and legally. Strategic trust structures for inheritance protection. One of the most powerful ways to keep your inheritance protected is through the use of trust. Whether you're passing down wealth to a loved one or receiving it yourself, the right type of trust can make all the difference. Let's break down 3 trust structures that can help protect your inheritance from divorce. Discretionary trust. A discretionary trust gives your trustee the authority to decide when and how to distribute funds to the beneficiary. That means the beneficiary doesn't have direct access to the trust money, and neither does a divorcing spouse, because the beneficiary doesn't own the funds outright. The assets in a discretionary trust are typically shielded from division in a divorce. This structure works especially well if the person leaving the inheritance wants to maintain control and minimize risk. It's important that the trust be carefully worded and administered correctly. Otherwise, a court may still consider the funds accessible or subject to division. Inheritance trust. An inheritance trust is designed specifically to hold inherited assets so they remain separate from marital property. This type of trust is often created by the person giving the inheritance. It names the child or heir as the sole beneficiary. What makes this trust effective is that it keeps the inherited assets out of the recipient's personal name. Even if the recipient later marries, the inheritance remains inside the trust and isn't subject to community property laws. If you're leaving an inheritance to a child or loved one, setting up an inheritance trust gives them a layer of legal protection they can't get with a simple will or outright gift. Dynasty trust. A dynasty trust is designed to pass wealth down through multiple generations while avoiding estate taxes and divorce claims along the way. It keeps assets in the bloodline and protects them from being pulled into future spouses' claims or creditor issues. This kind of trust is especially useful for families with substantial wealth or those who want to preserve assets for grandchildren and beyond. The dynasty trust creates long-term protection, ensuring that what you've built stays in the family and isn't diluted through divorce settlements or poor financial decisions. In California, dynasty trusts can last up to 90 years or longer, depending on how they're structured. With the right language and administration, they offer powerful safeguards, other legal measures to protect inheritance. Trusts are powerful, but they're not the only tools available. There are other legal measures you can use to protect your inheritance, whether you're planning ahead or already married. Prenuptial agreements. A prenuptial agreement allows both parties to spell out exactly what should happen to individual and shared assets in the event of divorce. If you've already received or expected to receive an inheritance, you can clearly state in the prenup that it will remain your separate property. This is especially important if you plan to use inherited funds to buy a house, start a business, or invest in other assets. Without a prenup, those investments may become marital property. Prenups protect both spouses by setting expectations up front. Postnuptial agreements. If you are already married, a postnuptial agreement can still offer protection. It works similarly to a prenup, but it's signed after the wedding. You can use it to reaffirm that an inheritance belongs to one spouse and will remain separate in the event of divorce. Keep in mind, postnups are more closely scrutinized by the courts, so they need to be drafted carefully. You should each have separate legal representation, and the agreement must be fair and fully disclosed. Keeping inherited assets separate. Without a formal agreement, you can take proactive steps to protect your inheritance by keeping it completely separate from joint finances. Using a separate bank account for inherited funds, avoiding using inherited money to pay shared debts, or make joint purchases. Not adding your spouse's name to inherited property titles, keeping detailed records that trace the origin and use of inherited assets. This is especially important when the inheritance is used to improve a shared asset, like making renovations to the marital home. Without proper documentation, it may be difficult to argue later that those contributions were separate. If you're unsure about how to handle inherited funds, talk to an estate planning attorney before making any transfers or purchases. A simple conversation could save you thousands, if not more, down the road. Inheritances are meant to protect and support you, but in California, that protection doesn't happen automatically. Whether you're planning to leave a legacy or you've already received one, you need clear legal tools in place to keep it safe from the emotional and financial disruption of divorce. If you haven't started your estate planning yet, or if you need to review your existing plan, give us a call at 408-945-3950 for that initial consultation. We'll guide you through the process and help you create a plan that fits your needs. And if you found this video helpful, don't forget to hit like and subscribe. We'll see you in our next video.